Good morning and welcome to Vermont House Judiciary Committee. And we are looking this morning at H.183, a bill regarding crimes and sexual assault. And we're going to start with the bill's lead sponsor, Representative Sarah Copahanzis. And welcome, and thank you so much.
Thank you so much for having me this morning. I appreciate the opportunity to help you understand a little bit of the background that brings H.183 to your table today. This bill, the origins of this really date back 3 or 4 years now to the time when I was working on sexual harassment prevention legislation. And I had a young person come to me and say, thank you so much for the work you're doing on sexual harassment, but there's so much more we need to do on sexual assault, and here's why. And from that moment, I've had, sort of in the back of my mind that we need to come back to this issue. But what really brings me here today, brings me not just as a citizen legislator, but as a former teacher of high school age students, a former coach, and a parent. And the experiences that I've had over the last year during this pandemic of being able to really slow down, take a seat around the fire pit outside and listen to the experiences of the young adults in my life really led me to the understanding that there are some really disturbing cultural trends that we need to recognize, we need to bring into the open, we need to talk about, because sexual assault has become disturbingly pervasive. Some of the conversations I have had over the last year report that there are there are sexual conquests that young people keep track of how many partners they've had. Those conquests have led to the lines of consent being blurred and have led to a lot of really disturbing outcomes for some of the young people in my life. And so the answer to this this conundrum is really multifaceted, and that's what you'll see when Michelle walks you through the details of the bill. But I think it's helpful just to orient ourselves to some of the statistics. And I have some national statistics, but also some Vermont-based statistics. Nationally, if there are, for every 1,000 sexual assaults, only 230 of those are actually reported to the police. Of the 230 that are reported to police, only 46 reports lead to an arrest. 9 of those cases are ultimately referred to prosecution. 5 of those cases, on average, will lead to a conviction, and fewer than those 5 convicted will ever serve time in jail. And so that disturbing lack of justice is really one of the things that was most apparent to me in the conversations that I have had over the last year with young people who have experienced sexual assault. Some Vermont statistics, I think, that are helpful to understand, and disturbingly, the Vermont Youth Risk Behavior Survey, which I'm sure this committee has had opportunity to look at from time to time, 9% of female students in Vermont report being physically forced to have intercourse that they did not want to have. 9%. That is a huge number. And unfortunately, 80% of those sexual assaults go unreported. And there are some really disturbing reasons for that, not the least of which is the sense on the part of survivors of sexual assault that nothing good will come of it. And so I think it's incumbent upon us to take some time to understand the impact that this has on the young people in our lives, and to do whatever we can as policymakers to prevent future sexual assaults from happening, and to educate people around us on what needs to happen to prevent sexual assault. So Michelle will walk you through the details of the bill, but there's four main goals of the bill. The first being modernizing our consent laws to be sure that we move beyond the myth that rape happens when a stranger jumps out from behind a bush and grabs someone, and really recognize that many of these unwanted sexual encounters are happening because of the presence of intoxicating substances. We need to improve our data collection, all right? Because I gave you those national statistics about how many sexual assaults turn into reports to law enforcement, turning into investigations, turning into charges filed. We need to understand where every step along the way, where this system breaks down. We need to make sure that we expand access to forensic nursing in all corners of the state. So you'll see a small appropriation in this bill, just in recognition that there are certain primary care settings where it's difficult for a survivor to access a rape kit. And also, finally, and perhaps most importantly for the future, I think we need to reintroduce the concept of a campus sexual harm task force. We need to ask our college campuses around the state to engage in a long-term effort to educate and prevent sexual assault, to help young people on college campuses understand what consent means. And then we need to take those best practices, and we need to recognize that that these activities start when these kids are in high school. So that is sort of the overview of what the bill does. And I really look forward to working with you on this, and happy to take any questions.
Any questions from the members of the committee? Or comments? Go ahead, Barbara. And then Selena.
Thank you for introducing this bill. This has been an issue that has been important to me since I started being a legislator. Since I represent part of UVM and part of Champlain College, I've had the opportunity, the misfortune of hearing people's bad experiences. And one comment that somebody said to me that just keeps ringing in my ear, that I'm hoping this bill can help address, is the legal process was worse than the sexual assault, because it felt like a very public and blaming version of it. And this person ended up having this happen again, which apparently is pretty common. Once you've been assaulted, there's a greater chance that you will be sexually assaulted again. And I forget which national group gave that statistic. But that person refused to take action again, because the reality is, as you said, so few people end up getting prosecuted. And so it's like a double whammy. So thank you for your efforts with this. And I'm eager to hear how we can address the horror for people who not only don't understand the system, find it intrusive, but then feel left in the dark and abandoned.
Absolutely, and thank you for bringing that up. And while my heart, when I think back to the conversations that I've had with young people who've experienced sexual assault, my heart wants to fix it all right now, because I know the traumatic experience that this has been for many young people in my life. But I also know that if we want to arrive at the right solution, long-term and globally, we need to understand the problem better. And that's why this bill takes modest steps towards modernizing our consent laws. But it also, more importantly, requires us to start collecting that data so that we can hear from the legal system every step along the way and understand where these breakdowns are happening. And that's how we're going to get to the point where we no longer have survivors of sexual assault saying, there's no way. Why would you ever put yourself through that? Just bootstrap yourself, figure out how to process whatever you went through, and don't tell a soul. And that's heartbreaking because I've seen the financial impact, I've seen the emotional impact, the long-term impact on people who have not been able to experience justice after having been wronged is just really disturbing.
Madam Chair, Selena is up next.
Great, great. And thank you so much. Sorry about my technical difficulties. Okay, Selena, great. Thank you.
Thank you. I don't have a question, just a comment. Just really wanted to thank you, Representative Copeland-Hanzas, for introducing this bill and offering the opportunity to co-sponsor. This is my legislative district, includes a huge number of college students, UVM, as does Representative Rachelson's UVM students and Champlain students. And this is just a concern that I've heard about again and again. And it's, you know, why last biennium we did advance a campus sexual harm task force, and I really appreciate the way you've built on some of that work. And one of the big themes in that group, you know, I think we were able to just kind of scratch the surface of getting started in that group. And so I appreciate your efforts to kind of carry that forward. But also one of the things we heard was just the challenges in consistency across campuses and particularly with really different definitions of consent operating from campus to campus. And so I think the work that you've done here with Michelle and stakeholders to really get more clarity, stronger language around what constitutes consent is it's really important in all settings, and just really want to voice appreciation for your thoughtful work on this and your personal connection to this issue. Thank you.
Thank you.
Great. Thank you, Selena. And I echo that as well. Thank you. Thank you so much. Okay, great. So I'm going to turn to Michelle unless Sarah, you have anything else to add at this point? No, great. Great. Thank you so much. Okay, Michelle, if you could do a walkthrough, please. I hope everybody has what they need in terms of the bill.
Yep, so we're just working with the bill as introduced, so hopefully everybody has that, and I'm not going to share the screen today, so I hope that's okay. If I'm going too fast or you lose your place, let me know and I'll slow down and try to get you reoriented. So Representative Copeland-Hanzas did a great job just kind of outlining what's in the bill for you, so she made my job a little easier there. And I know we have a lot of witnesses this morning. And so I'm just gonna do kind of a broad, overview, and I will go line by line and go through all the sections there, but I'll try to, I'm not gonna get too deep into some of the elements and things like that, because you know how that can go sometimes and can take up some time. So I'll be here all morning and can help answer questions, and I'll be listening to the witness testimony, and we'll circle back. I think certainly one of the issues that's going to be in there is mens rea, and we've talked a little bit about that and got into that subject on H.183, and so we're going to be kind of revisiting those kinds of issues, and I think that'll be one of the topics for kind of discussion between the witnesses. So, so starting on section 1, so we're dealing in chapter 72, which is the sexual assault chapter of Title 13 in your crimes and criminal procedure. And the first change is in section 1 under definitions. And you'll see On line 9, there is the existing definition of consent. And so you see there, it currently means words or actions by a person indicating a voluntary agreement to engage in a sexual act. And this adds that it's a knowing and voluntary agreement to engage in a sexual act. So you have that added piece there that it's that the person has knowledge of the sexual act and what's going on. It's not just the voluntary piece. The addition of the definitions on lines 12 and 14, so developmental disability and psychiatric disability, these are technical changes. So the statutes, a lot of the statutes in this chapter haven't been updated necessarily in certain ways. And so there was some kind of antiquated language, what we often refer to as, is changing terms to more respectful language. And my understanding from the disability organizations that these are the proper terms there. So this should not be changing it substantively, but should just be focused on using the correct terms now. So moving on to section 2. So this is our statute on sexual assault. So starting on subsection 1. So right now, no person shall engage in a sexual act with another person. And then right now, there's an added element of having to prove to compel the other person to participate in a sexual act. So that is struck here. And then you'll look in the subdivisions there. So no person shall engage in a sexual act with another person without the consent of that other person. So we'll go through, and there's a specific consent statute that we'll look at that will further kind of outline consent in this particular instance. It's not saying that you have to have affirmative verbal consent here, but we'll go through and we'll explore the consent language in a little bit. The second one is by threatening or coercing the other person. Third, by placing the other person in fear that any person will suffer imminent bodily injury. Or 4, when the person knows or reasonably should know that the person is asleep, unconscious, or otherwise unaware that the sexual act is occurring. Okay, and I will just give you a little peek into the big debate on this bill. I think in one of the issues is going to be the knows or reasonably should know. So using that kind of reckless standard on the should know, and whether or not prosecutors have to either prove that the person, let's say if subdivision 4 is looking at a circumstance where someone was substantially impaired by drugs or alcohol, should the actor have known that that person was unaware of what was occurring, or do they have to prove that the actor actually knew? So moving on to subsection B, and I'll just note here is that there's definitely some overlap in the provisions under this section. And that was my choice from a drafting standpoint, because I wanted to make sure that through revising the section, I didn't unintentionally lose something that was in the existing statute, because the sponsors were looking to expand. And so, I am your drafts person and your legislative lawyer, whatever, but I'm not, out there litigating these types of cases and stuff like that. And so I think we can narrow it down a little bit, because I think there is some overlap in these. And I just mentioned that because sometimes it'll seem a little bit like, well, wait, didn't we mention that up there? So I was trying to be careful about not unintentionally kicking something out. So under existing law in subsection B, no person shall engage in a sexual act with another person and impair substantially the ability of the other person to appraise or control the conduct by administering or employing drugs or intoxicants without the knowledge or will of the other person. So that's a situation where you kind of think of, somebody slipping something in a drink, right, to incapacitate the other person and engage in a sexual act with them. So that's just rewritten a little bit so that it's no person shall administer any alcohol, drugs, or other intoxicants to another person without the person's knowledge or against their will. And while the person is impaired by the alcohol, drugs, or intoxicants, engage in a sexual act with that person. Subdivision 2 is different and new, and that's not something that is specifically addressed in the current statute. And this is no person shall engage in a sexual act with another person when the other person is incapable of consenting to the sexual act due to A, impairment by alcohol, drugs, or other intoxicants. And that condition is known or reasonably should be known by the actor, or they're incapable of consenting to the sexual act due to a psychiatric or developmental disability, and that condition is known or should reasonably be known by the actor. So that one is addressing the issue of the person is impaired or either by alcohol, drugs, intoxicants, or they have a disability that impairs their judgment with regard to being able to consent, but it doesn't require that the actor in the case of intoxication actually administered the intoxicants to the other person. So that's where there's a difference with subdivision 1. Top of page 4, F and G, I just put that in there. There's no changes to the penalties in any of this. I just wanted you to be able to see what the existing penalties are for these offenses. Section 3 is where we go to the consent statute. And I looked at the legislative history for this. And other than a technical language tweak done, I think actually on the respectful language bill several years ago, this statute has not been amended or updated or anything since it was originally enacted in 1977. So there was the adoption of Act 51 in 1977 that put most of this sexual assault chapter together, and you've added to it over the years. But I just mentioned that in terms of the language, because it's good to kind of know what's the legislative history here. Have you guys been updating it consistently in the last several years? Have you not taken a look at it? And I can say that I think in the 20 plus years I've been here, I actually don't recall ever even working in this particular statute. So I don't know that we've ever, Eric might have taken something up or whatever, but I don't recall a discussion specifically around the consent issues, for a while. So you'll see in a prosecution for a crime under the chapter, so it's applying to the whole chapter, applying to sexual assault and aggravated sexual assault. You'll see the existing law says lack of consent may be shown without proof of resistance. And so there's a small language tweak there that changing it to more closely follow the federal definition, which is lack of verbal or physical resistance does not constitute consent. And so just saying that basically the fact that somebody didn't physically fight back or scream, or things like that, does not constitute consent. The second one is an expression of lack of consent through words or conduct means there is no consent. So if somebody says no, that means there is no consent. Submission resulting from the use of force, threat of force, or placing another person in fear does not constitute consent. Subdivision 4, a current or previous dating, social, or sexual relationship by itself or the manner of dress of the person involved with the accused in the conduct at issue does not constitute consent. That's, again, a little bit overlapping with another section that I'm not amending in here with regard to evidence and kind of the rape shield law, but it's kind of belts and suspenders here. Subdivision 5, a sleeping or unconscious person is unable to consent. And then subdivision 6, you'll see there's a lot there under existing law with regard to determining when people are incapable of consenting. And the main change in this particular subdivision is changing it from knows, like a knowing scenario, to knew or reasonably should have known. So the first one being that the person is deemed to have acted without the consent of the other person if the actor knew or reasonably should have known that the other person was mentally incapable of understanding the nature of the sexual act. Oh, and also I just want to mention is that this applies to L&L as well. So these standards, which is in another chapter. The second one is the actor knew or reasonably should have known that the other person was not physically capable of resisting or declining consent to the act. Third is the actor knew or reasonably should have known that the other person was unaware that the sexual act was being committed. So there, again, that's kind of like the instance of someone being intoxicated and out of it and not being aware of what's really going on around them. Fourth is the person knew or reasonably should have known that the other person was mentally incapable of resisting or declining to consent to the act because of a psychiatric or developmental disability. And finally, the person knew or reasonably should have known that the other person was incapable of making a knowing and voluntary decision to engage in the sexual act because they were impaired by alcohol, drugs, or intoxicants. So that's it with regard to the amendments to the statutory language with regard to consent. I'm going to move on now, if it's okay, to section 4 and then data collection. So this, again, this may need some tweaking, and I think it'll be helpful to hear from the witnesses about the best way to go about collecting this data. But we wanted to kind of get the outline there and talk about the kinds of things that the General Assembly is interested in collecting. So you see on or before July 1st of this year, every state, county, municipal law enforcement agency and every constable who has law enforcement authority shall begin to collect data on the following. The first one being the number of domestic and sexual violence cases reported to the agency or the constable. And second, the number of domestic and sexual violence cases the agency or constable refers to a state's attorney or the attorney general for potential charges. So how many cases are investigated by that law enforcement agency, and then how many are subsequently referred to a prosecutor. The second one is on or before September 1st of next year, and then annually thereafter. Every state, county, municipal law enforcement agency and constable who has law enforcement authority is required to report the data that they are collecting in subdivision 1. They're required to report it to VCIC. And then subsection B is on or before July 1st of this year, judiciary shall begin to collect information on the following: the number of domestic and sexual violence cases charged, the nature of the charge, and the disposition of those cases. That is something that may be available now. And the question is what's the best way to aggregate that information and get that to you? That might be something through crime research group or whatever. But the idea is that you're going to have the information. You'll see in subdivision 2 at the top of page 7 that they're going to be reporting the data to BCIC as well. Subsection C is not later than December 1st, 2023, and annually thereafter. BCIC shall aggregate by county the data that's in A and B and report that data to the General Assembly and post the data on its website so that it's accessible to the public. Okay. In section 5, this is the Intercollegiate Sexual Violence Prevention Council that Sarah spoke about. This is the result of, there was and I have to look at the name of the group. So there was the legislature in 2019 passed Act 77 and created a task force on campus sexual harm. That report came out last year, about a year ago, and one of its main recommendations was the creation of a council like this. And so this is based on that report. So you see that on line 12, subsection A creates the council for the purpose of a coordinated response to campus sexual harm. B, you have the membership. So I don't necessarily need to read to you all those folks, but there's a long list of folks who have experience either working with the issue of sexual violence or people or their education folks. So you've got the long list of people there who would be on the council. Subsection C, the council's duties are starting on line 15. So they're responsible for interdisciplinary planning and information sharing to support sexual violence prevention programs on every college campus in Vermont. They're required to do an annual review of data collected from climate surveys on sexual violence on campuses in Vermont. And they're required to do development and distribution of best practices and recommendations on sexual violence prevention, sexual health education, and strategies for mitigating sexual violence on college campuses. They're going to be staffed by the Network Against Domestic and Sexual Violence. They have a report due on or before December. I just have December there. I guess I'll pick a date, or you guys tell me what date you want to put it, but I guess I just put December. It was probably supposed to be December 1st, something. And annually thereafter, council has to report to the General Assembly with a summary of what they've been doing and any recommendations for you with regard to legislative action. So the rest is just kind of housekeeping, logistics, how it works with regard to compensation, things like that. Section 6, there's 2 appropriations. The first one is $13,000 for the network for the purpose of staffing the council. And then the second one is $40,000 to the Center for Crime Victim Services to be used in the forensic nursing program so that they can expand their services from, because right now it's just in hospital emergency rooms that these types of exams are done. And they want to be able to expand those out beyond hospitals to primary care providers and others, especially in areas where they're more rural, so that if you have a sexual assault survivor, they don't need to drive 2-3 hours to get to an ER to be able to have that exam, but they can go to someone locally. And so that's a $40,000 appropriation to expand that program. And then the effective date is this July.
Great. Thank you. Thank you so much, Michelle. That's very, very clear and helpful. It's great. Committee members, any questions? Not seeing any hands, but there we go. Will, go ahead.
Thank you. Going back to page 5, and let me get there myself. So going back to page 5, where we're talking about knew or reasonably should have known. So would that cover an aggressor who is themselves intoxicated? Because I think in a lot of occasions where a potential victim is being plied with alcohol or drugs in order to reach this unfortunate end, the aggressor is also consuming, just not to knockout levels. So I just wanted to make sure that the language in question wouldn't provide someone with being able to use a defense that they were intoxicated and were unable to reasonably process.
Right. I think that's an excellent question. And I don't necessarily have an answer for you on that. I think that that's going to be one of the things that we flesh out and discuss through the process of this, of taking testimony on this one. That's obviously something that happens pretty commonly. And then, trying to figure out, despite the actors' intoxication, should they still have reasonably known that the person that they were engaging in sex with was incapable of consenting. And so I think that's one of the tricky issues with this type of these types of charges. So I don't have a great answer for you necessarily on that one. I think, but I think it'll be a part of the discussion, I think, that we're really going to focus on.
Okay, thank you.
Sure.
Thank you. Bob. Can't hear you.
Probably never sounded better. Not sure, Greg. I'm sorry I didn't lower my hand. Representative Knott covered the exact same question that I was concerned about, a possible defense. And I appreciate his question and his concern. So, and I guess we're going to be addressing it. So thank you.
Great. Thank you. Anybody else, committee members? Give folks time to raise their hands or jump in. Okay. Not seeing anybody else. Great. Thank you so much, Michelle. Great. Appreciate it. Okay. I'd like to please welcome Chief Brian Pete.
Hello, good morning.
Good morning. Nice to see you. Good morning. Welcome.
As well, thank you so much.
You bet.
Well, I really appreciate the opportunity to be here. And I can, in reviewing specifically, I believe it was section 4 for data collection, I would just advise or recommend clear definitions on the data sets so we can make sure that we can avoid a garbage in, garbage out scenario. And that because we want to make sure that the quality of information that we're bringing in is going to provide you with the information you need to make the decisions going forward. And it also allows us and gives us additional time. We need to make sure we have that time to build structures for our record management systems, universal reporting systems as well. I'd also recommend that even though I know that the data collection is specific to this bill itself, is that to continue or consider broadening the scope of the data so that like right now, this is a very important thing, but other things that we can look at going down the road that we can anticipate that we're going to want to collect data on. So not just looking at crimes that are related to sexual assault or sexual violence, but what other things, data points do we want to capture that may have an impact on sexual assault data. Consider possibly looking at the crime research group to collect the data. I know that it says in there the VIC, but I think the crime research group also does data collection within the state. Again, and please forgive me if I'm incorrect, but I'm still trying to learn the layout of Vermont itself. And then just potentially the clearinghouse as SAs or state attorney's offices, as well as police departments, that we need to, again, defining the data that we want to collect, the type of data, so that we make sure that our numbers are the same, that there's not going to be a discrepancy in reporting numbers between the state's attorney's offices and the respective police departments.
Thank you. Thank you. I appreciate that. It's very, very, very helpful. Thank you. Were there other parts of the bill that you wish to testify on?
No, ma'am. I think there are other folks that are on the call that probably that have definitely a lot of more information pertaining to the law enforcement presence. But I do want to say that personally, I think that this is something that's very much needed. When I was in Little Rock and in Las Vegas, I was part of the rape crisis centers, volunteering to do that type of work, and it's you know. This is a very important work. So I just definitely leave it at that. It's just extremely important work. So thank you very much for the opportunity to be here. And if there are any questions I can answer, I will be more than happy and willing to do so.
Great, thank you. Thank you so much. And it's always good to see you. Thank you. Let's see, not seeing any hands, but again, I'll give folks a few seconds to reach out or, oh, guess not. Great. All right, thank you. Take care. Thank you very much. Okay, Lieutenant John McCollum, I believe you're here. I see a John. Let's see, is that?
Yes, I'm here, ma'am. Okay,
wonderful. Welcome. Good morning.
Good morning. Thank you very much for having me be part of this committee. I'm simply here just to convey Commissioner Sherling's position on the bill. Unfortunately, the commissioner wasn't available today, but he would like an opportunity to meet with the committee, if that's possible. And overall, the bulk of the bill appears sensible. The content, the wording appears sensible, enhancing protections and services for victims of domestic and sexual violence is a good endeavor. The commissioner would just like to have a little more discussion with the mandate concerning the data collection. I believe it's section 4. And just whether or not it needs to be a mandate as an appropriate mechanism. The commissioner would like an opportunity to talk a little bit about his modernization strategy, which within that includes a new statewide record management system, which would be used by all agencies in the state. So it'd be a statewide RMS that would be essentially able to collect the information, the data, the statistics that the committee is speaking about and interested in having. The commissioner can obviously speak more to the benefits of the vast data collection and reporting capabilities that it has, but just wanting to discuss if it needs to be a mandate or simply having it be available upon request for whatever data or statistics any group or committee is interested in having. Because again, the new RMS system will be able to produce any of these statistical reports, such as I think these data sets that the committee is interested in having. And that is all I need to provide insight on, I believe. If there are any questions regarding the information I provided, but.
Great, no, thank you. Thank you very much, it's helpful. And I do see that the commissioner did just join us, so we certainly can hear from him as well.
Okay.
But, any questions from the committee? Not seeing any. Commissioner, you're welcome to testify, or if you want to continue listening, that's fine too. But I do see that you're here, and I do want to acknowledge that.
I appreciate that, Madam Chair. I apologize for being so late. I've had COVID calls and testimony on the Capitol bill that just ended a moment ago. Or it actually hasn't ended. I just jumped off a moment ago. I think I don't have full context of your discussion at this point. So I'm happy to weigh in. For the record, Mike Sherling, Commissioner of Public Safety, and I do have an extensive background in sex crime investigations, having been both an investigator and director at the Chittenden Unit for Special Investigations for, I wish I could remember how many years, a number, 6, I think. I think before I go back to listening mode, relative to the data collection point of this, I think that was the main reason that I wanted to at least be on with you for a bit this morning, to flag as a reminder for the committee something we started talking about last year, which is we now have a contract in place and are beginning the deployment of a statewide computer-aided dispatch and records management system that will enable us to much more swiftly and accurately collect and report on a wide variety of data. And it's my hope that we move away from directing individual components of data to be collected and reports to be generated and move toward a more comprehensive rubric of public safety, in particular, leading the development of data dashboards and reports and open data that people can analyze on a host of topics across all of the information that's available through that new system, which will is actually online in about half of the agencies and has been for a number of years. And the other half and the state police will be moving to that system in July of this year.
Great, thank you. Committee members or Representative Copeland-Hanzas, a sponsor, if you have any questions. Okay, Selena, yeah.
Yeah, I really, really appreciate the work that's happening to create a comprehensive kind of open access to all kinds of data around public safety. So I very much understand what you're asking there, but I guess I just have a question about, you know, if we were to eliminate the mandate for this, like how would we have an assurance that this data would be, that this particular data would be collected and
I think Selena froze. Let's give her a minute to see if she comes back. But I believe yeah, if she can hear us or not. Let me reach out to her to see. See. Okay.
I think my connection dropped there.
Okay.
It automatically reconnected, which is impressive. I think I had started to say put a pin in the data component. This time next year, ask us to come in and show for you what data is available via the new system to track these kinds of events, and then begin to work from that as a starting point to inform what kinds of additional work we should do.
Okay. Thank you. Selena, you?
Yeah, I'm back. I really apologize. I think I caught the gist of the commissioner's response. So thank you for that.
Okay. All right. So you're good. Okay. Great. Thank you. Anybody else? Tom.
Yeah. Thanks, Commissioner. For whatever reason, what's going through my mind, I realize it's going to be, easier to share data, maybe have it all in one place for us. But is there any reason, or is it capable of connecting to out of state? It's just going through my mind because borders are just an imaginary line in a sense, and I didn't know if there's any benefit to that, or if it would happen to connecting to other networks.
The short answer is it does not. The federal government has experimented with a justice exchange standard a number of times over the last decade. Each of those efforts has been not fruitful, probably the best way to put it. In terms of data sharing across states, the primary way that is done is through a time-tested and robust system to share criminal histories and criminal charges through the National Crime Information Center, which is what the Vermont Crime Information Center exists in large part to do. But that only shares information about arrests and convictions that have not been otherwise eradicated through expungement or other means. It doesn't share the 85 or 90% of other events that law enforcement's responding to that may not yield a criminal charge. And with sex offenses in particular, we're not always able to get to a threshold of probable cause, but when you weave together one event that has been reported with another event that has been reported, sometimes that puts you over the line and you're able to bring a charge. So being able to track those, it would be beneficial to be able to track those across borders as well, but that is a bit of a challenge.
Great, thank you.
Okay, great. Anybody else? No. Okay, great. Thank you very much, Commissioner. I appreciate it. Thank you. Okay, looking at the time. Okay, let's go to Rebecca Turner from the Defender General's Office. Good morning and welcome.
Good morning. Can you hear me?
Yes, yes,
yes. Oh, good, good. All right. I'm Hopefully I won't have the computer problems on my end. Good morning. For the record, my name is Rebecca Turner. I'm the head of the Appellate Division of the Office of the Defender General. And I've been an appellate defender here in Vermont since 2007, and then took on the supervisor role in 2015. Reviewing this bill and getting the preview from Michelle Childs and reading the purpose section, I commend the endeavor to attempt to clarify this area of law, specifically consent and the issues of consent in the sexual assault statute. And this area of the law is indeed in need of clarification, spoken from the position as an appellate attorney before the Supreme Court, we litigate these issues over and over and over again. And so this bill comes with a lot of history and decisions by the Vermont Supreme Court. And by way of the introduction this morning, there was a point, there haven't been a lot of legislative amendments to the statute. And I would just like to point out to this committee that sexual assault, of course, is a common law offense. So we bring with it so much of that history, and that's reflected by how our court has treated it and how so much of how we understand these essential assaults have come through the decisions. And that, by way of introduction, I also wanted to add that when I went through the language of some of the proposed new language as to what should or shouldn't be consent defined in the negative, a lot of that does come from the decisions from the Supreme Court already, but much of the language here in the statute does not. And so I read this as greatly expanding the breadth of what type of conduct or what constitutes lack of consent. And so I want to make sure that the committee is aware that that is moving in a direction where I think is the opposite of the intent of it, which is to clarify this area. I think by broadening what means consent here just adds to the confusion. Confusion in the criminal context, of course, is not just that litigation becomes more complicated. Here we have a serious felony offense, max penalty, life imprisonment. So there are extreme consequences to what it means to us as to what is unlawful sex, and specifically, when is it not consensual? And again, in this context, the confusion that I think this bill adds to this area of law now raises to the level of due process concerns. And so to the extent that we'd be litigating that, what is the meaning of these terms here? I don't think that that will bring any more surety as to keeping this type of prosecution, these type of offenses, more definite and more discreet. And let me go through a little bit of what I mean by that. Now, of course, due process concerns in this context means that we have to have fair warning of what constitutes an offense. Fair warning can be broken down in a couple other ways and concerns. Fair warning in that it brings up the void for vagueness doctrine. We need to know with sufficient surety and certainty what, again, the standard is this: a person of ordinary intelligence has a sufficient certainty of what conduct is criminal. The other part of it is that it can't be so vague as to invite discriminatory or arbitrary enforcement. And so when I look at how consent is now being attempted to be defined, as pointed out earlier in the walkthrough, it's not just in one section of this bill, but occurs, let's see, 3251-3, 3254-1-5, 3252. So at least 3 sections of the statute we have, or I have to go through, we have to go through what is the meaning of consent or lack thereof, both defined here in the affirmative and in the negative. And so just focusing on that issue of what does it mean to not consent. I can walk through each of the sections here that raises that ambiguity and lack of clarity. But I wanted to first start with the 3254, section 1. That's page 4 of my bill, 3254. And here the language is trial procedure consent is the title. And here there's 1 through 6 new categories, new language that doesn't currently exist, defining what consent is or is not. And here it's established that lack of verbal or physical resistance does not constitute consent. So silence doesn't constitute consent. So then it becomes ambiguous. Well, then what then does require consent? We know in this proposed language 2 that a clear expression of no consent means there's no consent. That's fairly clear. But when we go back down through this and apply the other aspects to it, what I'm left with is really scratching my head. What does it take to have lawful consensual sex under this proposed statute in this state? Sure, it seems to me that unless you have written consent, no one can be safe from perhaps inadvertently committing this crime. And when I say inadvertently, because that brings in the other major concern of this proposed legislation, and that's going to the mens rea requirement, and that's on page 5, although that's also sprinkled in throughout. And it's the language reasonably should have known language, the new or reasonably should have known language. Again, the reasonably should have known brings this to a mens rea requiring less than the defendant or the person actually know that there was no consent. So when we combine this possibility, and then we add new language here too, and this is page 5, again in this same section, 3254, 6E. We have a new section that's added that would make it that someone who, I'm possibly going to the wrong, let me go to the other one. It's relating to the impairment of alcohol. 3254, 3, 4, 6. That's going to sleeping. Let's see. Hang in there. B12A, 3252 B12A. B12A. This is page 3 of the bill. This is new language, again, not currently in the sexual assault statute, but it's prohibiting someone from engaging in a sexual act when that other person is incapable of consenting. So essentially it's establishing that there is no defense of consent in this particular situation when there is impairment of alcohol and that the other person has impairment of alcohol. To me, that covers a potential scenario of a common date situation where you go out to a restaurant and have a drink, have a glass of wine. What does it mean to have the other person impaired by alcohol? Particularly when now we've dropped the mens rea requirement of engaging in consensual sex, where the person just should have merely reasonably known that they were impaired by alcohol. I think that when you layer on the changes of the language here throughout, the end result is something where we're left with really an inability to know when it is okay, when it is lawful to have sex in this state and not risk triggering and committing this potential life imprisonment offense. I can stop here because I feel like I can go through each of these line by line, and if that makes sense, or if I should just sort of hit the high notes.
Thank you. Let's see if there are any questions before I respond to that. Okay. Not seeing. Michelle, thank you.
I have a question. Hi, Rebecca. Nice to see
Michelle. You. Good to see you too.
I'm wondering, let's take the reasonably should have known. Let's take that out, just for discussion purposes. And then I'm wondering about your concerns, whether it's due process or over breadth or anything like that, if you didn't have the should have reasonably known.
Right.
So I'm just wondering about those aspects too, because I'm clear that how you feel about the reckless standard.
Right.
So.
No, and thanks for that question. That would absolutely be better, for sure, because now you're back into to bringing in that intent and the knowing, right, and making sure that it doesn't drop below that. The problem is that it doesn't fix this. It doesn't make the due process concerns go away. Let me give you an example. So I'm on page 2, 3252A, and there is a recommendation that we eliminate the critical language in the statute, and that's relating to compulsion. No person shall engage in a sexual act with another person. Currently, the law requires and compel the other person to participate in a sexual act. And then it goes through without the consent of another person, going down through to 4, when a person knows or reasonably should know that the other person is asleep, unconscious, or otherwise unaware that the sexual act is occurring. So the case law in Vermont, the Vermont Supreme Court has considered in what situations does compulsion differ from lack of consent, right? And there's a series of decisions on that. And what we have learned and what they've confirmed is that age of the complainant when a child is involved, right? Incest, you cannot consent to not be able to consent there because of the circumstances of that particular case. There is compulsion. So it collapses those two elements. They're not two elements, they're one element, right? On one level, that would seem that the proposed deletion would suggest that that is consistent. But again, the Supreme Court has gone through the specific cases where we can, where compulsion and lack of consent or the lack of ability to consent have been the same, but it's not always the same. Again, it's because of the narrowing of the circumstances involved in these cases, whether it's age of the accuser involved, whether it's the special relationship that the defendant has with the complainant, right? Parenting role, or a particularly vulnerable person who is in the complainant's position. Again, there's case law that develops whether compulsion and lack of ability to consent are one and the same. But again, the compulsion requirement, keeping it there and those circumstances not falling within those categories, helps to narrow the circumstances and again, provide better notice and fair warning as to what would otherwise require or be the difference between consensual and non-consensual sex between two adults without those considerations as to like age differences or relationship, mental disabilities and things like that. So there's that concern on due process. Moving down to 4, page 3 of that.
Rebecca, can I just ask a quick follow-up, and then I'll stop, so because I know I don't want to take over in the committee, but I guess I'm just wondering is, so I get like on the issue of the age of the victim, but we have that's specifically addressed elsewhere in the chapter with regard to the relationship of the victim to the actor and the age of the victim to the, and I guess I'm wondering when I'm looking at, the amendment, I mean, I get what you're saying on the compulsion bit, but if I look at the way that it would read under this proposal, so no person shall engage in a sexual act with another person, and then I go down to 4, and let's take out the reckless piece, would say, when the person knows that the other person is asleep, unconscious, or otherwise unaware that the sexual act is occurring. I guess I just don't necessarily quite see the issue with, so the person knows, so the actor knows that the person's asleep, unconscious, or unaware that the sexual act is occurring. I don't know why you need, for fair warning, for due process, compulsion in that particular case.
Well, and as the Supreme Court would agree with you, the State v. Snow is a decision on point on that, and you don't, that is yet another example that the Supreme Court has carved out where compulsion and consent are collapsed into one. And let me give you that site. It's 2013 VT 19. Again, the Supreme Court held there, reviewing the facts, consent is not a defense where a complainant is sleeping or unconscious. And so my suggestion there is, by adding that specific reference to the asleep, unconscious in language number 4, it's confusing what is already the case law in A1 without the consent of the other person. We have that Snow case that already says, well, you don't have consent when someone is sleeping and unconscious.
Well, I think it's just the goal is to say that specifically in here, so the average person doesn't look at the statute and have to know about the Snow case, right? And so we're trying to kind of bring some of the what's developed with the case law into the statute. And then the sponsors have chosen, to be more expansive than the case law. So I don't want to, you and I, let's get on email and we can geek out on the case law. It'd be great for you to send me some sites of some cases that you'd like me to take a look at and stuff, but I don't want to take up more committee time. Okay, thanks.
Moving, and I just want to point out in terms of B1, there's language shifting from substantial impairment. That was in the original language. Impair substantially the ability of the other person to appraise or control, B1. And the new language drops substantially and just makes it mere impairment. By the impairment by alcohol. Again, and
I'll just say that was intentional, because that provision is where the actor is actually drugging the victim. So the standard of it, so it's just they have to, without the knowledge of the victim, the actor drugs the victim and then engages in sex with them. So I think that wasn't, I could easily make an oversight on that by dropping the substantial, but it was intentional, but I respect your point there.
Okay. I understand. If the intent was not to change the substantive meaning from the first part, I think it does by dropping the substantial. Well, you and I can connect back on that. B2 again is where I worry that this captures a date, a restaurant where how much alcohol, what constitutes impairment of alcohol, and whether or not, if you bring alcohol into any amount of alcohol that results in impairment, that you don't do so without risking falling within this if sex happens afterwards. So there's that concern. And then 3254, again, this is a list of 1 through 6. Taking out the mens rea, what I'm left with is that when do you know that you have consent to have sex? And it seems to me the way that this is, understood, whether it's this section, whether you combine all these sections, you have to have it in writing. And then even then, I'm not even sure that that protects someone. And again, I put that in, let's 3254.3, which means that it's a crime, submission resulting from the use of force does not constitute consent. So even in the context where you have actual in writing that was the agreed upon sexual act that was going to, so it was consensual, but there's going to be involving uses of force. So, you know, I was thinking about how much we are starting to legislate actual types of sexual behavior when exploring what is consensual and what is not. Under this scenario, you know, 50 Shades of Gray with written consent that is okay. Does the 3254.1, where you submit submission resulting from the use of force does not constitute consent, does that take away and remove any of the prior written consent to have such sex? Again, I think that this is where we start to have ambiguity. This is where we have lack of clarity of what it takes, where someone can go and not go to not risk this triggering this offense. I want to move on to a different part of this bill, but before I do, I want to stress that the effect of this is to broaden what could fall within this this criminal category. And whenever you broaden the language to the point that you don't have fair warning, the due process concern is about the discriminatory effect. And one thing to keep in mind, particularly this offense, you know, we know that the overcriminalization generally is having very huge impact on racial minorities. When you throw in the extra historical context of how such biases against Black men have played out in rape accusations, I think that there should be very careful consideration of when we look into what we mean by no consent or consent, that we put in some clear standards so we don't perpetuate a problem while we're trying to solve another one. On the data collection section, my only suggestion here, again, we don't object to that suggestion. It is important for transparency to collect such information. I would only highlight that to make sure and check that there aren't any discriminatory practices happening, that the type of data collected also include demographics of the accuser, of the accused, of law enforcement involved, of the attorneys involved, of the judges involved, again, to get a full picture of how this is playing out in practice. Are Black men disproportionately being accused, being charged, being convicted, being overly sentenced? And so that would be, while we have this opportunity to collect data, I just don't want us to miss that opportunity so that we can make sure that if that's happening, that corrections can be made. On the recommendation on the council, or the proposal on the council, my only recommendation there is to make sure that that it be fair and balanced, and the proposed membership of that panel right now doesn't appear to include anyone from, for instance, communities of color or from the defense perspective. And so I would encourage that be considered in the draft here. If there are no other questions, I think I will stop here.
Thank you. Thank you very much. Barbara has her hand up.
So Rebecca, your last point is a really important one. And I am wondering how we walk that line of addressing a crime that currently is well underreported and under prosecuted, even though it is there's overrepresentation of people of color. I remember doing, when I was on jury duty, not getting selected for a case, and it was a refugee, and it came up, how many of you think not knowing English is a defense? And how many of you think local customs is a defense? And it was a pretty new refugee who was being charged with rape of a minor. The minor told him she was older, and it was like the saddest situation because this man did not understand at all what was going on, and he was convicted. And so, I mean, it doesn't make the situation better for the person the minor, but I'm just wondering, how do we thread that needle in a way that is as sort of just as possible? I don't know if you have thoughts on that.
I do, and I appreciate your concern, because there you're talking about layers of potential biases too that can come in, not just affirmative defenses that he could have in that instance, but the biases that come into play from all different levels. And I think that what could be done is to clarify, because I do think this area needs clarification. It just needs very, very clear standards. Mens rea shouldn't be anything less than knowing. If we require that the defendant know there was no consent, then that gets closer to avoiding all of those questions of, well, how am I misreading or misunderstanding a situation? You know, I truly had innocent, intentions. I took that silence as acquiescence, as willingness, as consent, right? So I think there's that. Start with the intent. Keep it at knowing. Don't let it drop to anything less. I think that whenever words and phrases are used to define what is lack of consent, again, keep it so that there's no room for ambiguity or ways to litigate the meaning of it. A sleeping or unconscious person, that's clear, right? As long as someone knows, the defendant knows, so the intent takes care of that, right? But again, the impairment level, the impairment of someone. So it means that alcohol and sex can't mix at all to be safe. What is that level? How do we understand that? The silence, right? This is the big question. I think that 3254, when you look at and discuss all of those things that do and do not constitute consent, what are we left with? What is it that we're requiring in this statute by default to make sure someone who's trying to comply with the laws doesn't inadvertently commit sexual assault?
Does it, I mean, given how confused our society is about these issues, and it seems so important to have a public education, like Representative Copeland-Hanzas spoke about working with colleges, but I think it's also working with public schools, working with new Americans for sure. Because we want people to not break the law, and it's going to be important. I mean, not just this law, but this one is one that there is prevention if we can do some public education. And I don't know, how that fits in with this bill, but just in general, I think it's something for us as legislators think about how do we educate our, how do we make it as easy as possible to be a good law-abiding citizen.
Great, thank you, Barbara. Okay, Felicia, and then we're gonna take a break, and thank you everybody for hanging in here.
Thank you. I just have a super quick comment to some of Rebecca's testimony, and I appreciate you being here. You mentioned acquiescence being unclear, and I think both in the education portion of outreach and understanding as to where exactly the boundaries lie, as well as existing case law, as recently as 2017 up here in Franklin County, it's quite clear that acquiescence has never been a marker of consent. And I want to make sure that as we continue our work on this bill, we do not insinuate otherwise in any way, shape, or form. It may not be as perfectly cut and dry as we might want any issue to be, but I don't think this issue is cut and dry. But on that matter, acquiescence is not consent and should not be used as a defense in any way, shape, or form. So I just want to make sure that my sentiment on that matter is crystal clear, and we are not letting that fall by the wayside as we move forward. Thank you.
Thank you.
Was that a question for the witness?
It was more my understanding of her comments, and as we move forward, something that I wanted to reach an understanding on.
Thank you. Okay, great. All right, Becca, anything else before we break?
No, thank you, and Representative Loeffler, I just wanted to say that I didn't mean to inadvertently misrepresent the current law, and you can see in 3254(1), which is crossed out now, but there it was clear lack of consent may be shown without proof of resistance, and so certainly that isn't, I'm not suggesting otherwise, and that in terms of that, I think the question then becomes, because this is where we have a life imprisonment max possible. How do we know in the bedroom, and just in going about our private lives, navigating these minefields generally with relationships and consent, but how do we know that we're not here in this most serious felony? And the definition of consent and not consent has to be crystal clear. And again, because of the due process concerns at stake, because we have a life imprisonment sentence at stake, and that's why the Constitution requires that kind of clarity. And so I just urge the committee to consider that as you navigate these tricky laws. And so, thank you.
Great, thank you very much. Okay, committee, let's come back at 10:45, take a 15-minute break. Barbara, I know you're going to appropriations. Thank you so much for doing that. I'm not sure if Ken is joining you or not, but if you want to, Ken, go ahead. Okay, thanks. We'll see you in 15.